Very good. Thank you. Mr. Hoskins.
Good morning, Your Honors, and may it please the Court. I'm Dave Hoskins, and joined with Max Brower. I represent Mr. and Mrs. Thompkins in this case. This is our fourth trip to the Court of Appeals in secondary mortgage cases. I'm glad to be back. I hope we'll have an opportunity to answer one of the remaining questions with respect to this statute that was passed in 1975.
Could I ask
Yes, sir.
Maybe it's a housekeeping question, I don't know. Was there a common law claim made?
Well, I guess I believe there was, and here's why.
Well, tell me where before you tell me why.
It's the paragraph I cite. It's not asserted as a count. It's asserted as an allegation, and the allegation, I think it's...
So it's cloaked
in
a factual averment?
But I don't believe so, Your Honor, because that sounds like a trap. But let me suggest it to you this way. I guess what I'm saying is I don't understand the reference you're making to Your Honor. When you do assignee liability, our position on assignee liability is it does not create the cause of action. Assignee liability creates a pair of shoes that you step into. And the cause of action in this case was always the statutory cause of action created by the secondary mortgage loan law. In a perfect world, there would have been a lender still in existence, and there would have been 2, 3, 4 defendants, the chain, if you will, of lending through assignment. And we would have asserted the same cause of action, a statutorily created cause of action created in 1975 under the secondary mortgage loan law. And we would have gotten our nexus, our hook, to get all of those defendants by alleging the critical fact, that one of the defendants was an assignee of a lender who had violated the lawsuit. So, Your Honor, and I understand where Your Honor's coming from, because obviously the Fourth Circuit believes that assignee liability can be treated as a separate cause of action. Judge Motz seemed to indicate, and that's what the Fourth Circuit latched upon, that if you're going to have assignee liability, then it's the fact of assignee liability that creates the ability to go after the assignee. But our position in this has always been, and especially, and I think this is where you get with 3306 especially, and even with the common law on assignments and on mortgages, is that 3306 is not creating a cause of action. It is saying, if you are not a holder in due course, then claims against a property or possessory interest can be asserted against you as an assignee who is not a holder in due course. That, in our view, is not a new cause of action. That is an avenue that allows the cause of actions that could otherwise only be asserted against a non-assignee, the originating lender, to then be able to be asserted against the assignee. And I think that's the... Yes, Your Honor.
I understand the theory that you've just espoused, but if we're concerned with notice pleading and all of that, how would someone who was responding to a complaint that has this inherently in it be able to respond to this? And because pleadings, you and I can both agree that pleadings are there for a specific purpose and answers and all of that. And it seems to me that your theoretical underpinning, the word came up, hiding, but let's take that aside, inherently does not give notice to the other side.
Your Honor.
Of this theoretical abstraction. And so how are they put on notice that they're being sued under this common law notion?
Yes, Your Honor, I understand the question. It's E21, okay? Right. It's actually paragraph 42, which was in count 1 and then repeated again. I don't think it was repeated again in count 2. But here's what
Is this the amended complaint?
I think I actually may have opened the complaint, but it doesn't change in the amended complaint.
I have the amended complaint. Where is that?
Your Honor, what page of the record are you at?
No, I'm not on the record.
Oh,
I'm
okay.
in your,
I will
your
refer.
petition for cert because I have the amended complaint.
E225.
Okay.
Which becomes new paragraph 36 in the amended complaint.
Okay.
And I'll come back to this. How an assignee is on notice is the assignee is sued.
Tell me where I have count 2. Is that what you're talking
Count
about?
1 is at the
Count
top
one,
of
and, right.
E225.
And that is, you're saying that,
Paragraph 36.
okay, 36, which says, as purchaser and assignee and holder of the note and the second mortgage of the plaintiffs, Mountaineer Investments is liable to plaintiffs because it is subject to all claims and defenses which the plaintiffs and members of the class could assert against mortgage lenders network. And that, from your viewpoint, in what you're asserting here, is sufficient notice
Yes,
of the world of claims and assertions.
of assignee liability. Yes, Your Honor.
So, in response, an answer would say, I deny that. And that would be sufficient to engender everything that one could think of.
Well, in reality, Your Honor, what would happen is either a motion to dismiss, because first of all, how are they on notice? They are sued, okay? And to the extent...
But we can both agree that that concept of being sued does not necessarily engender everything that an individual or a corporation could be sued for. That's why we have pleadings.
That's right, Your Honor. They're being sued. The recovery that is being sought here is a recovery that's provided by the statute. And they are being put on notice of an assignee liability theory. So how do they challenge that? They either say, we deny it, that it's exactly how it was decided here, Your Honor, through motions practice. Ultimately, this issue becomes the critical issue for which there are cross motions for summary judgment filed. Is there assignee liability under the secondary mortgage loan law? So there's no real issue in this case about the defendant not having notice that this was an assignee liability case. The only issue is, what is the legal theory? What are the various different ways to get assignee liability? And the terminology here is terminology that fits under both 3306 and also under the common law, subject to all claims and defenses which the plaintiffs and the members of the class could assert against the lender. So that's how they're on notice. And
But that would assume that, just take a situation where you have a breach of contract action. Mm-hmm. And the issue is breach of contract, and ultimately it comes up that it might be an equitable estoppel. You know, there may be there wasn't a contract breach, but there's an equitable estoppel because you have a promissory estoppel and all the things that you and I learned in first-year contracts. Under your theory, an individual or a corporation would be put on notice just under a breach of contract claim because equitable estoppel could be considered under different frameworks the same, as a contract claim, except it doesn't have the writing itself.
I appreciate the hypothetical because I think it proves my point, because that's the difference. You can't assert breach of contract and equitable estoppel as the same count. They're mutually exclusive counts. One count assumes there's a contract. So count one, when I have these situations where you have a contract or maybe a quasi-contract, count one, breach of contract. Count two, in the alternative, equitable estoppel. Okay, and they might have the ability to get you to the same place, and I think that's what drew your Honor's focus. They have the ability to get you to the same place, but that would be different here, because the only place we're going is return the interest under the secondary mortgage loan law. That's the only place we're going. And that's what count one says, in effect, a basic violation. Count two alleges perhaps a knowing violation. And by putting and the other facts, and of course the complaint also puts the assignee on notice because it goes through the transaction. It says it was lent from, and in this case the lender's name is Mortgage Lenders Network. Lent from Mortgage Lenders Network to the Thompkins. We allege the charges are in excess of the violation. Assigned. We are suing the assignee for the violations of the lender. Okay, so the only thing we haven't done, Your Honors, is we haven't set forth a count 3 that says assignee liability. But there is no, I would submit, Your Honors, I don't know of any independent cause of action called assignee liability. Assignee liability, to the extent it exists, especially under 3306, exists against assignees who cannot establish a cause of act, or who cannot establish holder in due course status. And if they can't, it makes them not subject to assignee liability. That's not what it says. It says subject to all claims, okay, of a property or possessory right. So under a 3306 pleading, and again, this is just my view, but I think it's a persuasive view, is that you don't allege a 3306 violation. You use 3306 to get access to another property or possessory right that could otherwise be asserted against the originating lender in this case. And that's what 3306 comes down to. And I mean, I sort of thought I would summarize the argument in 2 ways. One is can you do something about a statute that doesn't have specific assignee liability? Passed in 1975. We put in some public policy interests there, the suggestion that it was at that point an originate-to-hold model that then transferred to an originate-to-distribute. So the question is can this court do something when the legislature does not specifically speak? And nobody disagrees. That statute cannot be read, jumbled, backflipped to say assignee liability. I wish it could. But the question is there another avenue to get you there? And I think there are 2 avenues. And the one avenue is 3306, and we've got 2 conflicting federal opinions on that. We've got Judge Motz here says no, and we've got, and that's basically the opinion that has ultimately prevailed over the circuit court and ultimately prevailed over the Court of Special Appeals. But we also had the Williams opinion in Eastern District of New York that took the exact opposite. And the only difference was Williams used the old version of 3305, 3306. And yet we think we've demonstrated that the legislative history shows that if anything, the new version was supposed to clarify and expand. So the answer is yes. Can this court do something under 3306? Yeah. There's interpretations out there. The language is such that it can be legitimately read to allow a borrower to assert a statutory claim against an assignee. And I never raised this in my brief, but I was looking again at the language here. And you know how it says including a lien, right? A property or possessory right including a lien can be asserted against a non-holder in due course. And it occurred to me that that's kind of parallel to what you've got going on here. If I'm a third party who wants to assert a lien to a note that's held by an assignee, what am I trying to get? I'm trying to get what I call the proceeds. And that means I'm trying to get the monthly payments. I'm trying to get the interest and that piece of principal that gets paid every month. So when I'm asserting a lien against a note, I'm not asserting, maybe it's possessory, maybe it's property, but the real target is the stream of income. Okay? That's what you're trying to get. If you're a lien holder, you got a lien. I want to get that money because I have a right to it. And we suggest, Your Honors, that the secondary mortgage loan law provides that type of a remedy to a borrower. The ability to get back the interest, for lack of a better word. The ability to get back the cost.
Just had
yes, Your Honor.
Little question. But I thought was the loan paid off here before?
Absolutely, Your Honor.
So if there had been a lien...
Well, if there had been a lien in that case, absolutely not. But there still were proceeds paid on that loan. And that's the concept. So when that loan was paid off, all the principal had been zeroed out. All of the costs had been zeroed out because the costs were added to come up with a principal. People don't pay costs separate when they get a loan. They add it on to the loan. And a bunch of principal had been paid. And so, yeah, if it hadn't been paid off, everybody seems to agree, well, boy, they would have had a nice defense and maybe an offset and maybe a 3305 claim. But the facts before this case is within the statute of limitations as established by this court. Okay? They had a valid claim. And if the lender, let's take this, Your Honor. Let's say there was a lender who was viable. No, it was an originate to hold case. The lender is paid off. My clients could go against the lender and say, I paid $5,000 in interest. You have to give it back because I have a timely, valid claim for return of interest. And that's how we would say it works here as well. So that, yes, although a lien holder might not be able to do that in this case, in effect, this is the same thing that a lien holder would do in an active loan. You're going after the proceeds. You're going after what it develops. Okay? And so, the issue there is can we do something under 3306? Yes. Can we do something under common law? Yes. And I quoted to Your Honor's decision in the Pines case, and I know it's not on point. I get that. The point that I was drawing from it was Your Honor's distinction about how we should look at assignment law is whether or not it has a non-delegation presumption or the opposite. And because what I've been troubled by over these many years of dealing with these same cases is the federal court wants to use like the PT Holdings case, which is not on all fours, and I want to use these old mortgage mine cases that are not on all fours. But they're both part of the common law, and they both seem to say the opposite. And I think that Your Honor's decision gives us the roadmap around that explains that. And what it basically says is that in these contract assignment cases, we can have one rule, the non-delegation presumption. But in good old-fashioned mortgage assignment law predating the UCC, we can have the other. And I think that the Reismeyer case, of all the cases, is the one to draw focus on. Because believe it or not, that was a second mortgage. That was a second mortgage that got assigned to a third party, an innocent, potentially innocent third party. And then, there was some insolvency and the property got sold. There was enough money to pay off the first, and there was a pot of money left. And the question was, do the attaching creditors get the pot of money, or does the assignee of the second mortgage get the pot of money? And what the court held in Reismeyer was the attaching creditors get it because the assignee had to stand in the shoes of the originator of the second mortgage, and they didn't make the second mortgage correct. Okay? And so in some ways, that's a good parallel here. What we're saying under the common law is if you take a second mortgage, okay, that was made wrong, okay, and a lot of them were made wrong in 1998, okay, there's no question about that, and you purchase that as an assignee, then you stand in the shoes, you take over for the lender. And I think the principle that gets us there and gets us around the PTL Holdings contract cases is what Your Honor said, which is this going to be a non-delegation presumption? Or in this situation, are we going to say it's the opposite, a delegation presumption? And that answers, I think, Your Honor, the first question is, can this court do something when faced with a 1975 statute that creates an injury to borrowers that the legislature wanted to protect borrowers from? Let's just agree that the legislature did not want my clients to have to pay interest on this loan. By the time they figured it out within the statute of limitations, the loan had been assigned. Where we are right now is, remember we talked about originate to hold, originate to distribute? We're now originate to launder. That's the status of the law here. This loan was assigned at the closing table. And if there's no assignee liability, that's the way you get around Maryland mortgage lending law, is you immediately assign it to a third party because there's no assignee liability unless a statute specifically says there's assignee liability. So that answers the first question. And then the second question is should this court do something? And look, I know that this mortgage didn't cause the 2008 financial crisis, but it foretold it. And that's the whole point. Without an assignee liability, there's no ability, there's no market force that allows the policing of the market by the entities in the position to police. And unless Your Honors have any questions, I'll reserve. Thank you, Your Honor.
Very well. Counsel?
Thank you, Your Honors. I'm Gary Miles. I'm pleased to represent Mountaineer Investments on this argument. What I think is critical here to remember, and a case that is central to this decision that was not mentioned by Mr. Hoskins, was the Crowder case. The Crowder case determined that the SMLL, the secondary mortgage loan law, is a statutory specialty. It did not exist at common law. It's defined, created, and circumscribed by the language of that statute. And we all agree that the statute does not provide for any liability to an assignee. It provides liability only to a lender, and only to a lender who violates that statute. That is the sum and the scope of the secondary mortgage loan law that is created and exists only by the terms of that statute. It doesn't exist at common law, and Crowder expressly said that.
So does an assignment, an immediate assignment, basically kind of gut this law in terms of the obligations under it? Is that?
I'm sorry, Your Honor, I couldn't quite hear you.
Does an immediate assignment of a mortgage have the effect of basically gutting this law?
Absolutely not. And that argument is suggested by Mr. Hoskins in his reply brief when he says there's nothing that can be done affirmatively to prevent an assignee from collecting interest that the originator is not allowed to collect. We're not arguing that at all. Say, for example, this loan is assigned at the closing table, and it's known and clear, which it's not the case here because it's our position the fees were far less than what was allowed. But assume the fees do exceed it. Well, the lender is liable under 12-413. And this lender was, in fact, sued in 2003 by Mr. Hoskins. He was sued again in 2009 by Mr. Hoskins. He seeks $290,000 against the originating lender. So the originating lender still has liability for all the remedies under 12-413, including the excessive fees. But the assignee also under 3-305, which is not mentioned by Mr. Hoskins, but really is central to understanding the interplay of the statutes. The assignee would have bought a loan and then found out on day 2 of the loan that although it paid good money for this mortgage, it won't be collecting any interest because the borrower has a claim in recoupment. They can say, I don't have to pay you interest because under 3-305A3, I have a claim against the lender, and I can recoup that from the interest. So there's complete protection to the borrower. If they paid any excess fees, they collect that back from the lender, and they don't have to pay the assignee any interest. They have a windfall, a benefit. They have an interest-free loan, the purpose being to prevent a lender from charging excess fees. What lender would ever do that? Not only does a lender not collect the excess fees, they're liable under 12-413, and the assignee will sue them for selling them a bad loan. So the lender has motivation to comply with the law. The assignee has motivation to make sure the loan complies with the law, and the borrower has an absolute and complete remedy. But what happened here was in 2005, when my client bought the loan, there's a case pending where Mr. Hoskins has sued the lender and sued Master Financial, who assigned it to us. We bought the loan. He didn't sue us. We weren't added as a party. We weren't notified of the claim. His clients continued to pay the loan. They didn't assert a claim in recoupment. They paid the loan in full. The note was paid off in 2006. It was canceled. It isn't really a negotiable instrument then because it has no value. And more than 3 years later, Mr. Hoskins sues my client. So all the parties would be completely protected under the scenario where the loan is assigned at settlement. What this court has made clear in Gutman versus Wells Fargo Bank is that we cannot upset the plain language of the statute to reweigh the balance that the legislature struck. The legislature defined who's liable under the statute. A lender is liable. The lender's conducting the settlement. It makes sense. It's collecting the excess fees. It expressly decided that an assignee is not liable. I say expressly because there are other provisions of the law where a person is liable or an assignee is liable, but not under 12.413. That is the plain meaning of the secondary mortgage loan law, and that is what Mr. Hoskins is trying to avoid. The questions that Your Honors asked him were right on point. There is no allegation in the complaint of 3306 or even an allegation of the facts which would support a 3306 claim. So, for example, he doesn't allege that there's a note, that my clients, the plaintiffs, have a claim to that note, a claim on that note, and therefore they have a remedy under commercial law of Maryland because they have a claim to the note. And what's clear and what the Court of Special Appeals held and is indisputable is that 3306 does not provide them any relief because 3306 has to a claim of a property or possessory interest in the note or its proceeds. In 2009, the note didn't even exist, but whoever had a claim to the note, it was not the petitioners. They were obligated under the note. They were the payees under the note, but under no sense of the word did they have a claim to the note. And what is important to understand here is the interplay between 3306 and 3305, which is discussed in the briefs, but not mentioned by petitioners in their argument. 3306 has no applicability. 3305, by contrast, describes precisely the relationship between the payee under a assigned note and the assignee. And it says that the payee under the assigned note has a right of recoupment, has a right to make a claim against the assignee to the extent there are payments still to be made. And that is in 3305A3. And what's helpful to me, because sometimes I find the UCC a little bit obscure, are the comments. And this court has even cited in its cases the comments. And the comment 3 to 3305 is particularly pertinent. And just to humor me a little bit, it talks about a claim where someone sells a piece of equipment and the buyer has a warranty claim against the seller because there's some problem with the equipment. The seller assigns the note. Seller we'll call that the lender, assigns the note to the holder. We'll call that my client. But the buyer has a claim, a warranty claim. And the comment says, if the holder had notice of buyer's warranty claim at the time the note was negotiated, the holder is not a holder in due course. And the court below found, to my perspective clearly, and is raised by their petition for cert, that my client was a holder in due course. But let's assume hypothetically they were not. Buyer may assert the claim against the holder, but only as a claim in recoupment. That is, to reduce the amount owed on the note. If the warranty claim is $1,000 and the unpaid note is $10,000, the buyer owes $9,000 to the assignee. If the warranty claim is more than the unpaid amount of the note, the buyer owes nothing to the assignee. The buyer cannot recover the unpaid amount of the warranty claim from the holder. If the buyer had already partially paid the note, the buyer is not entitled to recover the amount paid. The claim can be used only as an offset to amounts owing on the note. If the holder had no notice of buyer's claim and otherwise qualifies as a holder in due course, that's this case, buyer may not assert the claim against the holder. So that makes it clear that if when suit was filed in 2009 there were any monies payable under the note, then they could assert a claim in recoupment. They could say, we have a claim against the original lender, and it exceeds what we owe you, we're not going to pay you. That's not the case here. They paid the note. They knew we were the holder of the note. They paid it off. 3 years later, they make a claim. And 3305 makes it crystal clear that that sort of claim under Maryland statutory law cannot be asserted against the assignee.
So would the assignee have any liability if the assignee were foreclosing on the mortgage?
I'm sorry, Your Honor?
If the assignee were foreclosing on the mortgage, which did not occur in this case, would that affect the assignee's liability in any way under this?
Well, that could under 303-305, Your Honor, because if they're foreclosing, there is, by definition, a balance owed. And if there is, this is a hypothetical, but hypothetically, if there is a valid claim, then under 3305A3, the borrower has a claim. I don't owe you $100,000 because I have a claim of $10,000 against the lender. I only owe you $90,000. Right. So in theory, yes, it would because there's a balance owed. But here there was no balance owed.
Right.
Now, why is 3305 important? 3305 is important because it describes precisely the relationship between these parties, which 3306 does not. But more importantly than that, if Mr. Hoskin's argument on 3306 were accepted, then 3305 is meaningless. That whole comment, which goes on at great length, would have no significance.
But if there were violations and he was owed money, that would reduce the full amount owed by the amount that he should have not been charged. And isn't there some sort of equitable claim he has to that money, even if he actually paid off the mortgage?
No, Your Honor, he would not, because 3305, the clear language of 3305, says the only claim that can be made is to offset amounts due. What they could have done, if they felt they had a claim in 2005, December of 2005, my client asserted a claim, they could have filed an action for declaratory relief. We don't owe you because the originating lender, who we've sued separately, owes us money.
Yeah.
And we have a claim in recoupment. But that demonstrates that Mr. Hoskins isn't making a claim under the UCC because he would have made that claim if he had had it. But he didn't make that claim. Instead, the clients continued to pay and, in fact, paid the loan off early. It was not due to be paid in full until 2018, and it was paid off in 2006. They paid it off 12 years early. Without protest, without force, they paid it.
They refinanced?
I'm not certain. I assume so, but I'm not certain. Let me shift to the argument about common law, unless we have any more questions. What I do think is important to remember is that the common law can't be used to change the clear meaning of statutes that are passed by the legislature. The language of the SMLL is clear. There's no dispute between us that it does not apply to assignees. The language of 305A3 is clear. Common law cannot be used to change that statutory scheme, particularly with a statutory specialty that this court held in Crowder did not exist at common law. This whole claim is a creation of the legislature, and it sets the bounds for it. There is a presumption that obligations of the assignor are not assigned to the assignee when the mortgage is assigned. And one of the provisions cited by Mr. Hoskins in his brief at page 10 is Real Property Article 2-103. Real Property 2-103, it's at page 10 of his brief. And it talks about the rights granted by an assignment of mortgage. Our legislature has addressed this as well. It says every valid assignment of a mortgage is sufficient to grant to the assignee, my client, every right which the assignor possessed under the mortgage at the time of the assignment. And that fits within the Cumberland Coal cases. If the lender didn't have any rights, if it was a fraudulent mortgage, then my client would have bought nothing if that was the case. But what this section does not say is that the assignment of a mortgage also imposes on the assignee the liabilities or the obligations of the originating party. So that statute is relevant as well.
I have a question. It may not specifically have to do with this case, but in reading through the secondary mortgage loan law, I saw that in one subsection it says a lender shall permit the borrower to prepay, and then there's a certain refund that's allowed if that's done. Does this mean that if the loan is assigned, there's no right to prepay? I mean, obviously they did it in this case, but
no, they would continue to have a right to prepay, but they wouldn't have a right to pay the loan off as they did here.
No, but I mean that the statutory right says a lender shall permit the borrower to prepay, and so the assignee is not stepping into that obligation, I take it.
Not directly, but since that document is assigned, since the assignee's abilities are circumscribed by the deed of trust in the note, they would be bound by the language of that, and that provision would presumably be in those documents.
So it would only be if it were in the mortgage itself or the deed of trust or the note.
And almost every one has the right to prepay, as was done here. So in this case, there was a prepayment, and I believe there almost always is that right. So at common law, there is a presumption that unperformed contract obligations of the originating party are not assigned. Pines Plaza affirms that. Pines Plaza adopted that same theory and did not change it at all. There is discussion in Pines Plaza of Restatement of Contracts, Section 328. And the footnote there says that, quotes the restatement and says that unperformed contract obligations, if the restatement section were accepted, which it has not been, but if it were, it only says that unperformed contract obligations are presumed to be assigned. Now here, there are no unperformed contract obligations. The loan was paid off, the loan was released, the contract was completed. So there are no unperformed contract obligations. The restatement never says that the assignee assumes all statutorily created independent liabilities of the assigning party. So even if the restatement were accepted, which it has not been, it would not have any applicability whatsoever in this case. The other point, again, is there's no common law claim that's asserted. A fair reading of the complaint indicates that the petitioners only sued under the SMLL. They sued only for SMLL remedies. They made no claim, for example, that the lender had some unperformed contract obligation, that by virtue of the assignment, that contract obligation was now my client's obligation, and that obligation has not yet been performed. There's no allegation of that at all, and the reason is that's not the case. Every contract obligation was fully performed, the loan was paid, and the loan was released. In terms of public policy, I addressed that somewhat earlier, but it is very clear that these petitioners had ample remedies, and they could have sued the lender, and they did, for $300,000, $296,000. They could have sued the assignee, Master Financial, which they did, and they could have sued my client if they wished to and had a valid claim in 2005, but they did not. They continued to pay the claim, pay the lien, they paid it off in full, and it's been satisfied. I close by emphasizing that our legislature has established a clear and consistent statutory scheme. The SMLL is a statutory specialty. 3306, 3305 describe the relationships between these parties, and common law cannot be used to overturn the plain meaning of the statute. Thank you, Your Honor.
Thank you, Mr. Miles. Mr. Hoskins?
Excuse me.
Thank you, Your Honor. May it please the Court. I think I have 5 points. First of all, a history lesson. My clients could not sue the respondent in 2005 because of a case known as Miller versus Pacific Shore Funding, which said the statute of limitations was 3 years from the date of closing. That changed in 2009 when this court issued its opinion in Crowder and said the statute of limitations was 12 years from the date of closing. And that's why this lawsuit was filed in 2009, could not have been filed in 2005.
Well, it
without
could have been, and then you would have been Crowder.
And I would have been Crowder. Well, I was Crowder, Your Honor. Let's not forget. Crowder was the only state court case that didn't end up in the Fourth Circuit. And that's how we got this law changed. Because all my other cases ended up in federal court and became Miller and Miller Fourth Circuit. And the law of the land, when no federal judge would certify that question to this court, was 3 years from the date of closing. We had one case that stayed in state court, and that case became Crowder. And that's how we got this court to rule on what the Maryland law was. So let's not get sidetracked about what my clients could or should have done. They were in a federal court case that was disposed of by the wrong reading of a statute. Okay? And that's what's happening again here. We've got the state courts are again following Judge Motz's decision that in effect says there should be no assignee liability. Okay, so let's not get sidetracked about they could have had a remedy against the respondent. They didn't get that remedy until 2009, and that remedy was a 12-year remedy. And that's the second point I'd like to raise, I think, in response to Judge McDonald's question. You have a statute, it's arrows in a quiver. Obviously, there's some of those arrows you can shoot at the lender. Some of those arrows you can shoot at the assignee if the loan is still ongoing. But one of those arrows is a 12-year statute of limitations to get your interest back. And if you've paid off your loan in less than 12 years and you've overpaid, you could bring that case against the lender if it was originate to hold. And nobody would say, well, you know, you should have come to us before you paid it off, and you could have brought it as an offset. No. If it was an originate to hold, the lender was Maryland National Bank, which was around in 75 when this statute was read. Maryland National Bank gave you a second mortgage, and they never sold that mortgage, and you overpaid. You got 12 years to get back that overpayment. And that's the arrow in the quiver that evaporates. And that's the arrow in the quiver that's gone. And that's why the Court of Special Appeals said, why are we talking about 3305? This is not a 3305 case. Well, the reason they want you to talk about 3305 is they want you to answer my second question, no, which is don't do anything about it, court, because there's other fact situations where a borrower might get a remedy against an assignee. They might get a remedy against an assignee under recoupment. Okay? And so since they might get a remedy under assignee under recoupment, let's just forget about those other arrows in the quivers that they could use against the lender. And my position is that's why I've never argued 3305. I get it. It's not a recoupment case. The question is, and when the commentary says claims under 3306 are different from recoupment, this is what it means. You can't get in recoupment more than you paid in because that's not recoupment. If you paid in more than, if your claim is greater than what you paid in, the only way you can get that is 3306. That's how they work together. And Your Honor, another I wish I'd thought about this, and I don't know off the top of my head the prepayment provision, but I will let the court know. I think that came recently. I don't think that was in the original. And a lot of what we're seeing in mortgage lending laws, this is a perfect example, is it's not the option of prepayment. It's the option of prepayment without penalty. That's the key, okay? A mortgage company would always like you to prepay. The concept, though, and what the legislature was dealing with, I think it was about 4 or 5 years ago, was there were a lot of these exorbitant prepayment penalties. And why do assignees want prepayment penalties? Well, why did the industry think there should be a prepayment penalty? Because the only way they make their money is if you pay interest for years. So if you get a loan and it's an assigned and you immediately prepay it or pay it off, they feel that they've lost something. So the industry started developing these prepayment penalties. And the legislature reacted by going back and amending all these statutes and saying, this is what you can do with respect to penalties. But they didn't apparently do a very good job at amending the secondary mortgage loan law. Because Your Honor's absolutely right. What if this court is faced in the future with an SMLL claim based on a prepayment penalty charged by an assignee? Okay? And the statute said, and that would be, in effect, conduct, all right, charging a prepayment penalty by an assignee that violates a statute that doesn't define a person you can sue, lender, as the assignee. And that's exactly what we alleged here at the time, which was basically there was a closing cost violation by the lender. The statute doesn't give me a direct cause of action against the assignee. So I got to get there some other way. And that's why I think that the prepayment penalty question does a good job at framing this debate. And I think the last point I'll raise, unless there's some other questions, Your Honor asked the question, well, what about this immediate assignment? And they say, oh, no, you get all the remedies against the lender. Okay, so if a prescient borrower in 1998 realized that they'd been overcharged, et cetera, et cetera, et cetera, you don't. And why don't you? Because the statute talks about may not collect interest. Okay, and so, and there are a few other allegations. If in the complaint, obviously the complaint alleges that there's a note, that's paragraph 19 at E220, and it alleges at paragraph 224 that $72,000 in interest was paid over the life of the loan. Okay, and since that loan was assigned at the closing table, none of that interest was paid to the lender. It was only paid to assignees. And so if the lender were still viable, and obviously why aren't they here? They all went bankrupt. They're not viable. They're not here. The lender would say, I have no liability for a return of interest because I did not collect interest from your borrower client. The only parties that collected the interest were assignees. And the remedy provided is a return of the interest. And that was Judge Wilner's recent opinion on this issue about what should the court do in a usury setting. And that's why I cited that case as well. The court seems to suggest that if it's a usury, i.e. return of interest, too much interest, the court finds a remedy. That was the Live Nation case. And it's because of the difference and the special relationship all of the courts at common law have had with respect to dealing with issues of usury. And SMLL, this court, and the Court of Special Appeals, every court that's addressed it has said, in effect, the secondary mortgage loan law is at its heart a usury statute. I appreciate, again, the opportunity to appear before your honors and discuss this very important statute. And unless there's any other questions, I think that'll be it.
All right,
Thank you, Your Honor.
Thank you very much. Mr. Hoskins, Mr. Miles?